Today, we're looking at two absolute giants of the Americas, Canada and Brazil. I mean, they're both these huge, diverse federations, right? But the way they built their legal systems, completely different foundations. Let's dive in and see how they did it. So, this is the big question we're tackling. How do you even begin to construct a system of justice for countries this massive and varied? You'll see that Canada and Brazil took wildly different paths, and digging into those paths, well, it tells us a whole lot about how they were formed and how they think about the role of law itself. All right, here's the game plan for this explainer. We're going to start with how each country actually became a federation in the first place. Then, we'll get into their core legal operating systems, super different. After that, we'll check out how their highest courts work. And finally, we're going to uncover this really surprising shared philosophy, right at the heart of it all. Okay, first up, federalism. Now, you might hear federal system and think they're pretty similar, but how they got there is a story of total opposites. One was built by piecing things together, and the other by slicing one big thing apart. Think of it this way. Canada is kind of like building with Legos. You've got these separate autonomous provinces, and you click them together to make a new, bigger thing, a country. Brazil, on the other hand, is more like slicing a giant cake. It started as one big, unified empire, and then they had to carve it up into states just to manage its immense size. One is bottom-up, the other is top-down. And this really drives the point home. Brazil wasn't uniting a bunch of powerful, independent regions. Its provinces were, frankly, pretty powerless. Federalism was a decision made from the top, a direct reaction to the super-centralized empire. It was actually imposed by military decree first, and only later written into their 1891 constitution. And you know, that top-down approach has led to this fascinating history where Brazilian federalism has just swung back and forth like a pendulum. You can see it here on the timeline. Since 1891, it's gone through these 5 really distinct phases, constantly bouncing between periods of strong central control, like under the Vargas and military regimes, and then swinging back to more decentralized power, which is what we see in the New Republic. So that's the blueprint of the House. Now let's talk about the very language of the law itself. Because if federalism is the structure, then the legal tradition is the operating system running inside it. And here again, Canada and Brazil are speaking two completely different languages. So let's break this down. Brazil runs on a civil law system, which it gets from Roman law. The main source of truth is a big, detailed, written civil code. A judge's job is basically to investigate and then apply that code. Canada, though, mainly uses common law, which comes from England. Here, the law is built up piece by piece over centuries through judicial precedent, what we call case law. The judge is less of an investigator and more like an impartial referee, interpreting how the law has evolved. But here's where Canada gets really interesting. It's what's called a bi-jural nation. Get this, while most of the country is on common law, the province of Quebec operates on a civil law system. This means the Supreme Court of Canada is in this totally unique position. It sits at the top of both systems, fluently speaking both legal languages. It's pretty amazing, actually. Okay, so this brings us to the highest courts in the land. How do these incredibly powerful courts decide which cases even get through the door? Well, their approaches couldn't be more different, and it shows you a lot about what they think a Supreme Court is even for. In Canada, it all comes down to 2 little words: leave to appeal. Since a big change back in 1975, the Supreme Court has almost total control over what it hears. It doesn't just take any case. Instead, it acts like a super selective gatekeeper. You have to ask for permission, and they only say yes if your case has public importance. This totally transformed the court from just being a final court of appeal into a really powerful lawmaking institution. So there are basically 3 ways in. The main one, for almost everybody, is applying for that leave to appeal. Then there's a tiny number of cases, usually specific criminal ones, that have an appeal as of right. They don't need permission. And third, the federal government can just ask the court for its opinion on a legal question. But the big takeaway here, it's all about quality over quantity. And then there's Brazil. The contrast is just staggering. In a single year, its Supreme Federal Tribunal, the STF, can decide over 100,000 cases. This is not a gatekeeper, it's a floodgate. It handles everything from huge constitutional fights down to what seems like pretty minor stuff. And it's led to constant calls for reform. All right, for our final section, we're going to peel back all those layers of structure and procedure and look at the philosophical heart of these two systems. And what we're about to find is this really surprising, really profound point where they actually come together. What's so important here is that both systems have these built-in tools to make sure justice isn't just about blindly following rigid rules. In Brazil, they talk about the social function of property or acting in good faith. In Canada, common law has this whole branch called equity, which is all about fairness, using tools that can stop someone from using the strict letter of the law to get an unfair result. You can see this idea so clearly in Brazil with something they call the constitutionalization of civil law. It sounds complicated, but it's not. Basically, after they got their new constitution in 1988, thinkers started saying, hey, our old civil code needs to be brought into the modern world. It has to reflect our new constitutional values, like human dignity. It was all about making sure private law actually served the public good. And that leads us to this incredible insight. Whether you call it good faith in Brazil or equity in Canada, what you've got at the end of the day is, and I love this quote, a sort of judicial magic wand. It's a tool that lets a judge reach beyond just the black and white text of a law and make a decision based on conscience and what's fair. And really, that's the whole ballgame. That's the biggest takeaway here. One system was built bottom up, the other top down. One speaks common law, the other civil law. But deep down, both Canada and Brazil have found ways to make sure that the law is a tool for justice, not just some inflexible machine. They both get that law needs to have a conscience. Which leaves us with one last question to chew on. As these two massive, dynamic nations keep changing, how are their legal systems going to keep up? If law really is a mirror of a society's values, what transformations are we going to see reflected in the courts of Brazil and Canada in the years to come?